Today, we will discuss the importance of maintaining the same federal employer identification number, or EIN, when moving your existing company, which might be a corporation, partnership, or LLC, from one state to a new state, and how to accomplish exactly that. Business owners often mistakenly assume that moving their company from one jurisdiction to a new jurisdiction is just a matter of filling out a few easy forms online. That is false, and that false sense of simplicity and security is the single biggest cause of inadvertent company death during a redomestication attempt. The Secretary of State will not tell you what documents to file, how to prepare them, or how to protect yourself from legal and tax consequences. And the Federal Internal Revenue Service, or IRS, will certainly not warn you before it sends a five-figure or larger tax bill for getting it wrong. Every month, our law firm receives panicked calls from business owners who thought they could handle it themselves, and of course, they made a mistake. In this video, we will discuss the particular importance of maintaining the EIN and how to accomplish that important objective. My name is Chad Cummings, and I am an attorney and a certified public accountant serving clients in matters of business, tax, and commercial law throughout the great states of Florida and Texas. I am Chief Executive Officer of the law firm Cummings and Cummings Law. I also teach business law at the university level and hold 4 degrees, including 2 law degrees, together with a variety of tax, financial, and accounting credentials, which I apply for the benefit of my clients in my practice of law. Our firm website is www.cummings.law. Every legitimate business in the United States has one defining identification number. That is the Federal Employer Identification Number, sometimes referred to as an EIN or FEIN. It is more than a tax identifier. It is the legal and tax DNA of your company, the numeric identity that the Federal Internal Revenue Service, state tax agencies, banks, vendors, customers, and credit bureaus all use to recognize your business as a continuing living entity. Losing your EIN is not a simple paperwork issue. It is the corporate equivalent of cardiac arrest. When the EIN disappears, the business's legal existence, financial history, and institutional continuity die along with it. Many business owners make the catastrophic mistake of thinking that forming a new business or merging an out-of-state company will automatically preserve their EIN. It will not in many cases. The Internal Revenue Service treats the EIN as inseparable from the legal entity that first received it in almost every case. Once that entity has been dissolved, merged, or replaced, the EIN must be terminated. Only one legal process, redomestication, which is also sometimes referred to as redomiciling or entity conversion, preserves your EIN because it keeps the same legal entity alive while simply changing its state of domicile. What follows is a detailed explanation of why keeping your EIN is so crucial, what happens when you lose it, how redomestication preserves it, and why other methods such as foreign registration, merger, or dissolution and reformation usually fail disastrously in this regard. The EIN is the permanent taxpayer identification number issued by the IRS to a specific legal entity. It is attached to that entity's life cycle from the day it is formed to the day that it is ultimately dissolved. All federal tax filings, payroll deposits, information returns such as Forms W-2, 1099, 940, and 941, and income tax payments are tied to that identifying number. State tax authorities, licensing boards, banks, and others use it to verify and validate the entity's existence and compliance history. Dun & Bradstreet, Experian, and Equifax use it to build commercial credit profiles. Your EIN connects every critical aspect of your operations: payroll accounts, bank loans, insurance policies, leases, contracts, and merchant processing relationships. When that number remains constant, the outside world properly recognizes that your company has continuous existence and credibility. When it changes or is terminated, every counterparty will assume that the old entity has been terminated, and they may not know that a new one has been created. And in any event, the number does not carry over. The practical impact is devastating. Frozen payroll accounts, invalidated credit histories, and IRS confusion that can take years to resolve. When an entity dissolves, merges, or reincorporates without going through the redomestication process, the IRS requires a final return under the Treasury regulations. The EIN assigned to that prior entity is then retired and terminated with finality. The IRS does not allow transfer or reuse of that EIN for any new entity, even if the ownership, management, and operations are identical. Though after a period of time, to make matters even worse, they may reassign that EIN number to a new company. Can you imagine the confusion that would create for you? You must apply for a new EIN, which means that all previously linked accounts, federal tax deposits, electronic filing credentials, and payroll systems must be re-registered. Banks and payment processors will almost certainly immediately detect the mismatch between the old and new numbers. They may place holds on accounts, delay deposits, or terminate relationships altogether due to perceived, if not actual, fraud risk. Credit bureaus will close the prior credit file and open a new one, wiping off years of favorable and valuable payment history. SBA and commercial lenders often treat the new entity as a startup with no credit worthiness. The practical result is a catastrophic loss of continuity. The business that has operated for years now, in some cases, is no longer in existence and is forced to rebuild its credibility from scratch. When a company loses its EIN, the IRS interprets that event as a termination of the taxpayer. Depending upon the entity type, this can trigger serious federal and state tax consequences, including 6- and 7-figure bills and even larger in some cases. For corporations, a merger or dissolution followed by reformation is treated as liquidation under Internal Revenue Code sections 331 through 336. All appreciated assets are deemed sold at fair market value, thereby creating taxable gain. For Subchapter S entities, the election terminates because the old entity has been liquidated. The new entity must now reapply and may be altogether ineligible due to shareholder changes or timing issues. For entities taxed as partnerships, which includes most but not all limited liability companies, under the Treasury regulations, a partnership terminates by default if 50% or more of the interests are transferred or if the entity ceases to exist. Dissolving or merging an LLC or a partnership into a new state entity without going through the redomestication process generally triggers this unfavorable rule, closing the tax year and potentially accelerating income recognition for the owners. Many states also impose franchise taxes, minimum taxes, or excise taxes upon dissolution. Once the entity ceases to exist, those tax accounts are closed and final returns become due immediately. In contrast, a properly executed redomestication handled by a competent and experienced attorney avoids these headaches because a redomestication constitutes a continuation, not a liquidation. The entity will retain its legal and tax identity. The IRS and state authorities continue to treat it as the same entity and the same taxpayer with no new EIN required and no recognition of taxable gain or loss. Redomestication, sometimes referred to as conversion or continuance, is a statutory mechanism that allows a business entity formed in one state to change its jurisdiction of organization to another state whilst maintaining uninterrupted existence. Legally, it is the same entity before and after the change. Only the governing law and registered office change. Because there is no dissolution, merger, or new entity formation, the IRS views the entity as continuing without interruption. Treasury regulations and IRS guidance confirm that redomestication is a non-recognition event that does not affect the entity's EIN, ownership, or tax attributes. The same EIN, bank accounts, payroll accounts, and contracts remain valid. The business simply continues under the laws of its new home state. This is why redomestication is the only lawful and reliable means in most cases of moving a business to a new state while maintaining the same EIN. Many other options create a new taxpayer, whether by design or by default, which is what is to be avoided. Let's talk about some of the other workarounds that I just alluded to. Foreign entity registration, for one. Some owners attempt to register their existing out-of-state company as a foreign entity in the new state, believing it accomplishes the same goal. It does not. The entity remains domiciled in its original state and continues to owe franchise taxes and annual reporting fees there. You must also file reports and maintain a registered agent in both jurisdictions. You have not moved your company, you have, in many respects, simply duplicated it. Worse, if you withdraw from the original state, you will forfeit your legal domicile and may be forced to apply for a new EIN number anyway. Now let's talk about statutory mergers in this context. A statutory merger requires you to form a new Florida entity and merge the old one into it. The new entity is sometimes referred to as the survivor or surviving entity, and the federal employer identification number of the old entity is extinguished. The IRS treats this as a liquidation of the non-surviving entity. The old EIN is terminated, and you must therefore notify all agencies, financial institutions, customers, and vendors of the change. The merger process itself is lengthy, complex, and expensive, and the end result is still the loss of continuity that you were trying to avoid altogether. Now let's talk about dissolution and reformation. This is the worst possible option. If you're considering this, stop. Put down the keyboard, put down the mouse, back away from the computer, and call an attorney right now. You are going to make a serious mistake if you go this route. This is the worst possible option, as I said. Dissolving the old company permanently terminates the EIN. Once dissolved, the entity ceases to exist. The contracts are all terminated. The liabilities become personal liabilities of the owners. It cannot be revived because there's nothing left to convert. The new entity must apply for a new EIN, file new tax registrations, and begin from scratch. From the perspective of the IRS, the old company distributed its assets to the owners, who then contributed them to a new business, an event often taxed as a liquidation followed by a capital contribution. If that sounds complicated, it usually is. Now, in contrast to all of that, redomestication satisfies the dual objective of changing domicile and preserving both legal and tax continuity. Let's talk a little bit more, though, about the practical consequences of losing the EIN. Even if the IRS issues a new EIN quickly, the collateral damage has already been done. Payroll deposits tied to the old EIN will not match the new one, creating reconciliation nightmares and potential penalty notices. State unemployment agencies may close accounts and require re-registration, delaying wage reporting. Financial institutions verify entities through EIN matching. A new EIN can trigger account freezes under anti-money laundering and know your customer protocols. Merchant processors similarly may delay or withhold deposits until ownership and identity are re-verified, which is not a quick process in many cases. Business credit bureaus will close the file linked to the old EIN, wiping potentially years of payment history and credit scores. SBA and commercial lenders often treat the EIN of the new entity as that of a startup, voiding prior credit facilities or requiring personal guarantees. Government contracts, Private contracts, professional licenses, and insurance policies frequently identify the entity by EIN. A change in EIN, therefore, may require reapplication, renegotiation, a new round of underwriting, and reapproval, potentially and seriously disrupting operations for months. This administrative havoc is entirely preventable. Proper redomestication preserves the same EIN, avoiding this cascade of failure. Business owners often believe that they can explain the change to the IRS or lenders by a simple phone call and quote unquote clarify that it is the same business. Good luck. That belief is naive and dangerous. The IRS, state tax agencies, and financial institutions do not make subjective determinations based on your intent or goodwill. They rely exclusively on the legal continuity of the entity that holds EIN. If the original entity has been dissolved, merged, or reincorporated without properly undergoing the redomestication process, the IRS simply has no discretion. It must treat the entity as terminated. That is why the only way to preserve the EIN continuity is to use a mechanism that keeps the same entity legally alive. Redomestication statutes specifically provide that all assets, liabilities, rights, and obligations remain vested in the continuing entity because it's the same entity. No taxable transfer occurs, and no new taxpayer is created. The IRS continues to recognize the same EIN because the legal personality of the entity never changed. The preservation of the EIN through redomestication has remarkable downstream benefits across every aspect of your operations. Your contracts, licenses, and insurance policies remain enforceable. Your IRS and state tax accounts remain open and synchronized. Your payroll, merchant, and banking relationships continue without interruption. Your Dun & Bradstreet number and business credit history remain intact. Your vendors and customers will never notice a change in the legal structure. In other words, redomestication accomplishes what every other method fails to do. It moves your business legally and cleanly while keeping your existing financial, contractual, and tax infrastructure intact. In conclusion, if your business's EIN is its lifeblood, as it almost certainly is, redomestication is the only safe transfusion, to use a pun. Mergers, foreign registrations, and dissolutions are amputations disguised as surgery. They sever the legal identity that connects your company to the IRS, your bank, your vendors, your customers, and your credit history. Once that identity is gone, there is no way to resurrect it. Redomestication, handled by a properly licensed and competent attorney, allows you to relocate your business to a new state whilst preserving its EIN, contracts, reputation, and tax status. It is a single, precise legal act that achieves what every other approach cannot: a clean relocation without financial and operational debt. If your business is valuable enough to move and it is valuable enough to protect, then why would you take any chances? Preserve your EIN, protect your credit history, your credibility, and your name, and move to the new state the right way through a lawful redomestication prepared and filed by an attorney who understands both the law and the tax code. Again, my name is Chad Cummings, and I hope that you found this information helpful. As always, the information in this presentation is general in nature and is not legal advice, because legal advice, by definition, must be specific to a particular set of facts and circumstances. Should you have any questions regarding this information or the content of any of my earlier presentations, please visit my firm website at www.cummings.law, not .com, but .law, to schedule time for a consultation. I look forward to the opportunity to speak with and perhaps even work with you very soon.